Okay, picture this for a second. You're a federal employee, right? And you get injured on the job, you do everything by the book, you share, sensitive medical details, maybe just a doctor's note with HR or your supervisor. You're assuming, naturally, absolute discretion.
Yeah, of course.
But then the unthinkable happens. You actually overhear coworkers gossiping, and they're discussing specifics about your injury, details you only shared through official channels.
Oh,
It's just a total gut punch, right? And it immediately makes you ask some pretty critical questions, like how much medical information is my supervisor actually supposed to see? What happens if that info gets leaked? Who should have access? And, what are the real consequences if confidentiality is broken?
It's a really terrifying scenario.
Yeah.
And unfortunately, it's not just hypothetical for some people. What's interesting is, while it feels like this deep personal betrayal, it's also a very serious legal issue. There are specific rules governing this, especially for federal employees.
That's a really powerful way to frame it. And it highlights exactly why our mission for this deep dive is, well, so crucial. We want to cut through all the noise, all the information overload, and just deliver the essential insights on federal workplace medical privacy, kind of the need-to-know version. We want you, our listener, to feel well-informed and, frankly, empowered. So let's dive in. What are the foundational protections federal employees actually have when it comes to their medical info?
Right. So federal employees actually have surprisingly strong privacy protections. A lot of this comes from the Rehabilitation Act of 1973. This basically applies the standards from the Americans with Disabilities Act, the ADA, It applies those to federal agencies.
Okay.
And here's the really critical part. All medical information you give them, whether it's for, say, a work injury claim or a request for disability accommodation, or even just a simple doctor's note for sick leave,
Yeah.
all of it must be kept confidential.
And confidential means, practically speaking, not just in theory.
Exactly. In practice, it has to be stored separately from your regular personnel file.
Okay.
And access must be restricted only to authorized staff.
So your supervisor, for instance, can't just, stick your medical papers in your general office file or leave them out on their desk.
No, absolutely not. That's a really significant practical protection. They can't do that.
Okay. So that naturally leads to the next question. If all medical info is confidential, what can your supervisor actually see?
Yeah, good question. The core principle here is strictly, and I mean strictly, need to know.
Need to know.
Your supervisor can only see the information that's absolutely necessary for them to do their job, specifically in relation to your situation. So this usually means things like work-related restrictions or accommodations, not the nitty-gritty diagnostic details.
Right. Okay. So could you give us some concrete examples? What might a manager actually be told?
Sure. They might be told about necessary work restrictions, things like light duty required for 6 weeks, or maybe telework needed twice a week for medical reasons, that kind of thing.
Makes sense.
Also, in emergency situations, maybe first aid or safety personnel could be informed if there's a specific risk. Like if you have a severe allergy or perhaps seizures, they might be told what to do if an episode happens at work. But again, only those who need that specific info for safety.
Okay. But what about the flip side? I think this is where a lot of the confusion comes in. What don't supervisors need to know? What's usually off limits?
Well, in most cases, specific medical details, like your actual diagnosis or your full treatment history, that's usually not your supervisor's business. Unless, and this is the key, unless it directly impacts the specific workplace accommodations you need.
Can you give an example of that?
Yeah, so let's say you request schedule changes because of maybe a mental health condition.
Yeah.
Your boss typically only needs to know that you require the schedule adjustment for medical reasons. They usually don't need to know the underlying condition itself. The rule is very strict. Access and use of that information has to be limited, really limited to what's needed for their duties.
Okay, so the supervisor is just one piece of this puzzle. Who else in the federal system might legitimately need to see your medical information, and why?
Right, it's not just the supervisor, but again, it always comes back to that need-to-know principle. First, you have designated HR folks and sometimes specific medical personnel within the agency.
Okay.
They're usually the ones actually handling the medical documents and maintaining what's called your employee medical file, or EMF.
EMF, got it.
Generally, it's only HR or perhaps a dedicated workers' comp coordinator who sees the full details.
And then, as we just talked about, your direct supervisor or manager.
Right. But as we covered, they operate under very strict limits.
Yeah.
They only get the info absolutely essential for their supervisory duties related to your health situation, like those work restrictions or accommodations, they definitely don't get like free rein to just browse through your private medical records.
Okay. What about other people outside of HR and your direct boss?
Well, first aid and safety officers, like I mentioned, if it's relevant for emergencies. Think about someone with diabetes who might need sugar or insulin.
Right. It makes sense for safety.
Then you might have EEO or compliance investigators. That's equal employment opportunity.
Mm-hmm.
If you file an EEO complaint, or maybe if they're just auditing compliance with disability laws, they might need to access relevant medical information as part of that process.
Okay. And workers' comp.
Yes, absolutely. If you file a federal workers' compensation claim, your medical information will definitely be shared with the Department of Labor's Office of Workers' Compensation Programs, that's OWCP, and potentially also with your agency's own internal workers' comp people.
Right.
And sometimes, if an employer-provided insurance requires a medical exam, they might receive relevant info too. But these are all permissible disclosures only for those specific purposes.
So just to be absolutely crystal clear here, nobody else, like your coworkers or maybe other managers who aren't involved, they are completely out of the loop.
Completely. Absolutely not. There's another important law here, the Privacy Act of 1974. It strictly prohibits federal agencies from disclosing personal data, like medical records, to unauthorized individuals, or, for that matter, for purposes other than why the information was collected in the first place.
So that means?
That means your coworkers, your subordinates, if you have them, managers who aren't directly involved in your accommodation or leave, they have zero right to know your medical details. Legally speaking, your health information is absolutely not fair game for office chatter or gossip. Only those officially in that need-to-know loop should know anything. And even then, only just enough information to do their specific jobs.
Okay. So with all these protections seemingly in place, it really begs the question, what actually happens when someone does cross that line? When a supervisor or someone else leaks private medical info, that's where things get really serious, legally speaking, isn't it?
It really is. Under the Rehabilitation Act, which we mentioned earlier, an unauthorized disclosure of an employee's medical information isn't just poor judgment. It's considered illegal discrimination.
Wow, discrimination.
Yes. The act of improperly disclosing or sharing that information without authorization can itself be seen as causing harm to the employee. That's separate from any other potential discrimination they might be facing.
So what does that mean in terms of legal consequences? Can you actually file an EEO complaint, an equal employment opportunity complaint, if this happens?
You absolutely can. You can file an EEO complaint specifically alleging a breach of medical confidentiality. And we've seen real cases where this exact thing is played out. Take the case of Jeannie P. She was a cook at a federal prison.
Oh, wow.
She took some medical leave for stress. Her supervisor then went and told other staff members about her condition and why she was out on leave, all without her consent.
Oh, no.
Yeah, and this led to gossip. People started treating her differently, some harassment. It actually made Jeannie's stress much worse.
That's just awful, a really distressing outcome. So what happened legally? What did the EEOC, the Equal Employment Opportunity Commission, say?
Well, Jeannie filed an EEO claim, and the EEOC ultimately found that the agency had violated the Rehabilitation Act by improperly disclosing her medical information.
Okay, so they found in her favor. What was the result?
She received $2,500 in damages for the emotional distress caused by the breach and the subsequent fallout. And importantly, the agency was ordered to provide remedial training to the supervisor and potentially other staff involved.
Now, $2,500 might not sound like a life-changing amount of money, but...
Right, but the ruling itself sends a very clear message. It shows the federal government, through the EEOC, takes these breaches seriously. It really underscores that agencies have a direct responsibility to make sure their supervisors know and follow these privacy rules. It's not optional.
And Jeannie P's case isn't like a one-off incident, right? This pattern shows up elsewhere.
Not at all. There's another case, Joanna G. versus the U.S. Postal Service. Joanna complained that her supervisors were sharing her confidential medical information with people who clearly had no need to know it.
And what happened there?
Well, initially, the agency dismissed her complaint, but Joanna appealed, and the EEOC actually reversed the agency's decision. They found evidence that multiple supervisors had indeed improperly passed her medical details around.
Wow.
So, yeah, just reiterates that need to know really truly means need to know. And it's not just one person. Multiple levels of management can be held accountable if they mishandle information.
So, beyond the employee filing an EEO complaint, what other consequences might a supervisor face internally for leaking info like this?
Well, internally, supervisors who leak confidential medical information can definitely face disciplinary action from their agency. This could range from, simple counseling or a formal reprimand, all the way up to more serious punishment depending on the severity and circumstances.
Okay.
Federal agencies have their own internal Privacy Act rules and strict ethics standards. Leaking medical info would likely violate those as well. So it's not just an EEO issue, it's potentially an internal conduct issue too.
And what about the impact on the workplace itself? You mentioned Jeannie's situation. What happens to trust when something like this occurs?
Oh, it's incredibly damaging.
Yeah.
Leaking medical information doesn't just break the law,
Yeah.
it fundamentally shatters trust and destroys morale within a team or an office.
Yeah, I can imagine.
Like we saw with Jeannie P. Once her supervisor blabbed, other staff started ostracizing her, harassing her. It created a hostile work environment.
Which is another legal violation in itself.
Exactly. So one initial breach, the disclosure, can easily snowball into creating a hostile work environment, which adds another layer to the legal problem for the agency and affects a whole office dynamic.
And crucially, let's talk about money. What about monetary damages for the employee in these situations? We mentioned Jeannie's $2,500. Can it be more significant?
Yes, it absolutely can be. If you win an EEO complaint or potentially a lawsuit related to this, you could receive compensatory damages. This is meant to cover things like emotional distress, harm to your reputation, and it can also cover your attorney's fees.
Yeah.
Now, every case is different, of course, but there have definitely been instances where federal employees received tens of thousands of dollars due to mishandled medical information, especially if the disclosure was part of a larger pattern of discrimination or maybe retaliation. But even in cases focused just on the illegal disclosure itself, agencies have had to pay out significant settlements or awards.
Okay, so this is really important information. For you, the listener, the federal employee listening right now, what can you do to actively protect your privacy? And what are the immediate next steps if you even suspect a breach might have happened?
Right, prevention and action. First, empower yourself just by knowing the rules we've been talking about. Be aware that your medical information is private and protected. And don't be afraid to question things. If you feel your supervisor, or anyone else for that matter, is asking for more medical detail than seems necessary for the task at hand, you can ask why they need it.
Is it okay to push back a bit?
Absolutely.
Yeah.
Politely, professionally, yes. Often, a simple doctor's note that just states, cannot work for X days or requires light duty is totally sufficient. You generally don't have to hand over your entire medical history. And it's perfectly okay to say, I'd prefer to provide the necessary documentation through HR if a supervisor is demanding more than seems appropriate. Involving HR can sometimes clarify the proper procedure.
Good advice. Now, what are some clear warning signs, like red flags that might indicate a potential breach has occurred?
Okay, the biggest red flag is probably if a coworker suddenly seems to know about your injury or your medical condition, especially if you haven't told them yourself directly.
Yeah, that's a big one.
Or if you start getting unwarranted questions from colleagues about your health, or if you hear rumors swirling around the office about your medical situation. For instance, if someone comes up to you and says something like, hey, I heard you have specific condition, is that why you were out? And the only official person you told was your supervisor, or maybe HR. Well, something's clearly gone wrong there.
Okay, and this next point feels like a really critical, almost Blinkist level takeaway. If you suspect a breach, you have to act fast. Is that right? How quick is quick?
Yes, extremely important. Federal EEO rules have very strict time limits. Generally, you only have 45 days from the date you first became aware of a potential confidentiality breach to contact an EEO counselor at your agency and start the complaint process.
Wow, only 45 days.
That's right. That 45-day clock starts ticking the moment you realize, or reasonably should have realized, that your privacy might have been violated. So prompt action is absolutely crucial.
So don't wait.
Don't wait. Even if you're not 100% sure you want to file a formal complaint yet, it's still vital to consult your agency's EEO office or perhaps a federal employment attorney who specializes in these issues as quickly as possible, just to understand your rights and options within that tight time frame.
Okay. And like with any potential legal issue, I assume documentation is key.
Oh, absolutely essential. If you suspect a leak has happened, start keeping detailed notes immediately. Write down who said what when you heard it, who you think might have had access to the information originally.
Keep everything.
Everything. Emails, names of potential witnesses, any kind of proof you might have that the disclosure actually happened. This kind of evidence is what will significantly strengthen your case if you decide to proceed. Going back to Jeannie P's case, there was likely testimony or other evidence confirming that her boss talked about her leave inappropriately. That evidence was absolutely crucial for the EEOC's finding in her favor.
Right. Now, here's something I hear all the time, a common misconception. People often immediately jump to, that's a HIPAA violation, whenever any medical privacy issue comes up at work. Is that usually the right framework for federal employees?
Yeah, that's a great question, and it causes a lot of confusion. Generally, in the federal workplace context, a breach of medical confidentiality is usually not a direct HIPAA violation you can act on.
Okay, why not?
Because HOPA, the Health Insurance Portability and Accountability Act, is primarily a healthcare privacy law. It mainly governs how health providers, hospitals, insurance plans handle your protected health information. It doesn't typically give employees a direct right to sue their employer just for, say, gossiping about their health condition.
So where does the protection come from then?
For federal employees, the protection comes from those other laws we've discussed, primarily the Rehabilitation Act, which incorporates ADA standards, and the Privacy Act of 1974. So you absolutely do have a strong right to medical privacy in the federal workplace, but the legal basis usually stems from these specific employment and privacy laws, not directly from IPI in most employer-employee situations.
That's a really important clarification. Okay, so if you do move forward with a complaint and it's successful, we talked about money damages, what other kinds of remedies might be possible beyond just the financial aspect?
Right, it's not always just about money. Other remedies could include things like requiring the agency to take corrective action. This might mean updating their policies, providing mandatory training on medical confidentiality for supervisors and staff, like what happened in Jeannie P's case.
Okay.
It could also involve disciplinary action against the specific individual who leaked the information.
Could you ask to be moved, like under a different supervisor?
Potentially, yes.
Oh.
If the trust with your current supervisor is just irrevocably broken because of the breach, requesting a transfer to a different supervisor or work unit could be part of the resolution. Really, any measures needed to restore a professional, non-hostile, and safe work environment for you could be on the table. The overall goal is always to try and make you whole again as much as possible, and crucially, to prevent similar violations from happening in the future.
Okay, so wrapping this up, if there's one core takeaway for you, our listener, today it really seems to be this. As a federal employee, you should feel assured that if you get injured on the job or have any medical condition you need to disclose for work purposes, it is not supposed to become office gossip or water cooler fodder.
Absolutely. There are strong, specific rules in place precisely to prevent that.
And you do have recourse if your privacy is violated. This isn't just, unfortunate office drama. It's potentially a serious legal violation with real remedies available.
Exactly. Your health information is your business, period. The federal government, acting as your employer, is legally bound to respect that privacy. Your supervisor isn't your doctor. They're not your family member. They don't automatically get access to everything about your injury or condition. They only get just enough information to manage the work aspects properly and safely, and absolutely nothing more.
And critically, if they betray that trust, if they leak that information,
the law is clearly on your side to hold them, and by extension, the agency, accountable.
In this day and age where privacy concerns seem to be growing everywhere, it feels vital to know that even within the huge federal system, your personal health story is legally meant to stay your story. Unless, of course, you choose to share it yourself.
That's the bottom line.
So remember, ignoring these privacy rules isn't just bad workplace etiquette for federal managers. It's a breach of a legal obligation, one with potentially significant consequences for the agency. Your personal health story is yours